Hello. Happy Monday, everyone. How are you? It's so nice to see everybody. Thank you guys so much for being here. I just have a little tiny bit of housekeeping to get to, and then we'll be ready to start the live. And I promise I'm going to stay all the way on task tonight because we got a lot. So the first thing I wanted to discuss is it was brought to my attention by a viewer that a lot of the intro has flashes and stuff like that that is triggering to photosensitive viewers. And I'm glad that they said something to me about it. So as you can see, the intro has a warning ahead of it. Hopefully that helps because I had epilepsy when I was a kid. And so, yeah, I don't want to do that to anybody. And I feel awful that I didn't even think about it. So there's that little bit of housekeeping. The second bit of housekeeping is I know that I'm super duper ultra late on, because I'm behind anyway, on the recaps of Life After Lockup with Gypsy Rose. It was due to a technical difficulty. Really, it wasn't all that technical. It was me. And I messed it up, and then I had to fix it, and then whatever. Anywho, so it's done. I just have to upload it to YouTube, so that will be ready tomorrow. We're on episode 5. And now that I figured out a shortcut, the episode shouldn't take as long. So hopefully I can have all of those done for you because I have other stuff pertaining to Gypsy that I want to get to and I want to work on. So that stuff will be all that Life After Lockup content is going to be on the second channel, A Dose of Jen Liu. I feel like there was one more thing that I wanted to say, but I have somehow forgotten it. So maybe it'll come back to me and I'll remember. Oh, I remember now. So the last bit is I'm very behind on the West Memphis 3 Wednesdays. I'm going to pick right back up. I am struggling, though, with a time to do it because I try not to be live when people that I am friends with are live at the same time, even though it's not the same subject. I don't like to do that. So I'm trying to work out a time. It might be 9:30, but it also could possibly be like 5:30 to get, to go ahead of, because usually Melissa Jade does her lives at 7:30. So I want to get back on that. And no, Neat Noodle, I sure didn't. Okay, I will, give me just a second and I will get you the, hold on a minute. I'll give you my link. Uh-oh. All right, here we go. This is the link to the second channel. I will add it to Nightbot after we get off of here. Hopefully, I will remember. I got it for you, babe. I just can't. I need to remember to add it to Nightbot. Okay, so I covered the intro. I covered Gypsy Rose Life After Love. I covered what West Memphis 3. All right, we should be good to go. So Sarah Boone went to court today. And it was basically the judge was going to hear her motions, which he did. Not all of them made Sarah happy. I don't think she understood some of them. I know that she was very adamant that particularly with the JAC. So let's start there, okay? Because that's where they started today. So one of the motions that Sarah had was she wanted funds for depositions. She wanted funds for a private investigator, and she wanted funds for a expert witness. Okay. So she wrote those motions to the court, and while the JAC would prefer that she make those motions to them because they're the ones that pay for it. So that was part of it. And the other part is that there was already funds allocated and paid to the private investigator who's already on her case and has been on her case since Bankowitz with Prison Break. Private investigators. So they said, okay, we'll continue to pay for that. The other two motions for funds, which were for depositions, because she wrote to be determined on the amount that she was looking for and who all she would be deposing, the judge denied her request with prejudice, but said that she could refile. And of course, she's reiterating and saying, well, I don't have my discovery. That's why I wrote that. Okay, calm down, Sarah. Nobody's mad at you. You're not in trouble or anything like that. They're just explaining the process to you. Okay, so that's basically what the same thing was with the expert witness. The expert witness, you have to give them the name, and the expert witness has to agree to take the standard pay rate from the JAC. So that's kind of that's where that was at. But the more interesting one, or the one that was interesting to me anyway, is this standby counsel. And I have to say that even I misunderstood. Standby counsel, and the guy from JAC, he really explained it very, very well. So basically the deal is this. standby counsel is there for people who have elected to go pro se. This way, there's already an attorney on the case. Should the person, the defendant, decide, wait a minute, this might not be a good idea, I'd like to have an attorney. That's what they're there for. What Sarah is asking for is an attorney. What she wrote in her motion was really for an attorney. It wasn't really for standby counsel. So, they're not co-counsel, and he explains that really, really well. So I will, without further ado, I'll stop explaining, and I will let the professionals do the explaining. And I've already got closed captions up and everything, so we should be good to go. Here we go. And I can see already from 2 seconds in that Sarah has decided today she's going to let a smile be her umbrella. Just kidding. She's frowning, clearly. Haha.
Case number 2020 CF 2603, the state of Florida versus Sarah Boone.
I forgot one thing before we get started. I want to thank Kate for the super sticker. Thanks. I appreciate that so very much. Very, very generous. And also thank you, Music City Mom, for being a member for 13 months. I appreciate y'all's support. And while we're talking about support, do your girl a favor and hit that thumbs up for me. Appreciate you. All right, now for real, here we go. Sorry to the people on replay.
State.
Steve Ketchum, on behalf of the state. William Jake of the state.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 3777.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get your appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed costs to acquire an investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18th, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As to the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is if we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay.
See, I thought that was rather nice of the JACS because they have a packet. They're going to give her a packet. This will help her in her future motion filing and to understand things and perhaps, just help her. The only thing that I don't understand is the court setup. I don't really understand, although I'm glad that it's, in a way, I'm glad because we get to see her, because if it was set up a different way, we wouldn't. But I imagine that not only is it difficult for Sarah to write because she's handcuffed, it's, she's having to use her knee as a table, and that's got to be a little bit difficult. But I mean, it is what it is. All right, here we go.
All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date, once I have that information, to revise them.
I'm giving you the opportunity to refile. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs to With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense and trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024 and received July 29th, 2024. The request, ma'am, that you were seeking in that motion.
I didn't want to pause while he was in the middle of telling her what he's going to do, but I have to pause for commentary. So I decided to pause here. let's listen in. I think I'm very, very curious about, let's just watch. I don't know how I'm curious as to how he's going to handle this. All right, here we go.
Is to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Okay, so for those just coming in, he's already gone through her first 4 motions, okay, which is basically she wants to be able to depose. She wants money for depositions. She wants money for an expert witness, and she wants money for a private investigator. The first 2 were dismissed with prejudice because they're not specific enough. And you have to be very specific, particularly with the expert witness. The judge needs, the JAC and the judge need to know exactly what kind of witness, what type of expert witness you need and why you need them. So it's got to be very, very specific. And it wasn't because, again, because as Sarah likes to point out 11 billion times, she hasn't gotten her discovery yet. She big mad, blah, blah, blah. Which I think is interesting because it isn't, Sarah's not had her discovery. Okay. That's a fact. She's not stretching the truth or anything, but it isn't as if none of her attorneys have ever discussed her case with her at all. It's not like she's not aware of what's in the discovery. Do you know what I mean? I mean, certainly she would be aware that there's 2 videos. I mean, they played one of them for her in the interrogation room. So she certainly knows about that. Leather and Lace says, what is the JAC role? They are who you go to as a indigent defendant to get money, to get the funds to pay for things like expert witnesses, depositions, all the thing, a private investigator. They're in charge of the money. So, and Patricia says, would she have to name an expert witness or just the type of expert witness? Well, she would both, I think, but I think initially the first thing that she would have to do is start with the type of expert witness she wanted. For example, when Bankowitz was her attorney, he wanted a mental health professional who specialized in battered wife syndrome, or battered spouse syndrome, I should say. That's a more correct term. In battered spouses. Unfortunately, her rate that she wanted to be paid was above what JAC, what their rates are. And so what Bankowitz had done was filed a motion to get her higher rate of pay. And in that, he would have had to explain why. Well, before any of that could happen, Sarah had written another really scathing letter, which she's allowed to write letters. It's just, actions have consequences. So she wrote a scathing letter, and it was after that next scathing letter that Bankowitz said, I'm done. And so that all came to a halt. So, yeah. So April Storm Peach Pie Pondu says, she does know a lot. She just doesn't know how to lawyer. I was wondering if one did take her up on her flyer and pro bono, do you think the judge would allow it? Yes, she can have a private attorney. He would allow it. What he would not allow is a whole lot of flexibility in say an attorney did decide to take her up on her, decided to take her case and took it pro bono. What he would not entertain would be a continuation of the trial or extending out the trial date in order to allow an attorney to prepare for trial. He feels like it's been put off enough, and that's that. He's done. She just can't have a public defender. All right, so let's keep going because this is the interesting one. This is one we all want to hear about. So without further ado, here we go.
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the courts had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul v. State, 152 Southern 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115. Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepherd v. State, 17 Southern 3rd, 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied. Do you have any other questions, ma'am, as to the court's rulings this morning?
Let's just take a little quick poll and chat, okay? How do you think, the question from the judge is, do you have any other questions for the court today regarding these rulings? How do we think Sarah is going to react? Think she's going to react with sunshine and rainbows, or do you think she's going to be polite but quite mad? I'm curious. What do you guys think? Also, I'm not sure who the cameraman is, but bruh, you're giving me Blair Witch vibes, and I'm going to need you to stop. Like, slow down, okay? You don't got to do it so abruptly. Yikes. All right, let's find out what Sarah Boone has to say about this.
First off,
Whoa!
I did not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity or if it's just something that is denied, period.
It is denied, period.
Thank you.
With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing is in regards to competency as opposed to having an understanding before you take someone's right to live.
That pertains to a criminal defendant's seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explaining most of all of this, and as opposed to prior, so I would know what happened or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence or the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you present.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay, I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the
Okay. Sarah, I know you can't hear me. This is for the people on the replay who like to remind me that Sarah can't hear me. I know she can't. Nevertheless, here I go. The thing is, and this is what Sarah is missing, she feels entitled to have written those letters in the way that she wrote them. See, it's not just that she wrote letters, okay? We've seen other defendants write letters. Nick Godejohn wrote a letter to his judge. Letitia wrote a letter to hers. Defendants write letters to judges. That's not the issue. It's not the letters. It's the content of those letters. It is the name calling in those letters. It's the language that she used. She berated in writing her counsel. Now, when you're writing to a judge to tell the judge, that your trial judge, that your attorney is not doing their job, and this is why, when you tell them that they are, or that your attorney is incompetent, and you list reasons why they're incompetent, that would suggest to me anyway, and I don't know about you guys, that you're not happy with your attorney, that you no longer wish for this attorney to represent you. Because if you feel like your attorney is not doing their job, and not only are they not doing their job, they are incompetent, meaning they cannot do their job. They cannot perform the necessary tasks and requirements and duties of their job. then why would you want to continue having them represent you? I do not understand this at all. Oh, Brandy, thank you so much. I appreciate that. Brandy says, I've been stalking your channel since court ended. I love your content. Thank you, babe. I appreciate that. Glad to have you here. I'm glad to have everybody here. But you guys take my meaning, right? If you're going to, like, it would be like me getting up here and talking all the smack about Shmita over here, right? And then Shmita hearing all the smack that I'm talking and saying to me, well, Jen Lou, I don't want to be your friend anymore. And I say back to Shmita, why come? I want to be your friend. Whatever would make you think that I don't like you or don't want to be your friend? Seriously, that's pretty much what she's done here. And now she's acting like she didn't know that she was doing that, or she didn't know that these would be the consequences of her repeated, barrage of letters, and it's the language that she used. I only picked on you, Shmita, because I know you can take it, because I would never quit you. I would never not be your friend. But yeah, and that's the problem. And what she wants from her attorney, and this is how her attorneys are all incompetent. They don't do what Sarah wants them to do. And it makes you wonder what it is that Sarah wants them to do, because it's got to be something that they can't do, Be like me walking into a hair salon and telling the stylist that I want to look like Farrah Fawcett. Okay. I'm brown hair, brown eyed. She doesn't, it's not like the stylist has a dadgum wand. Okay. It's no different than the attorney. They don't have a wand. They can't make your case any better than what it is. They can only work with what they've got. Anyway. All right. Let's get back to it. Enough Jen Lou talk. Let's hear what Boone has to say, because she's big mad. We're going to rewind it a couple of seconds here. Okay, because she believes that her order is erroneous. So let's hear about it, Sarah.
And after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that it's my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
Now, I have to say that I really appreciate the swiftness and the professional way that the judge shuts her down. I appreciate that. He doesn't get into a back and forth with her. He doesn't allow her to pontificate or expound anymore on her opinions, etc., and argue with him. The thing is, this would be the time for her to argue, but not the way she's doing it. If she could go through and argue the legal grounds why she should not, where he erred in judgment. You don't need to sit and listen to a person when they've written, 150 pages worth of letters, they're not, it's Sarah, it isn't like what you wrote was, a haiku, and we need to try to unravel it. It's not a riddle. We don't need to figure out what you meant. You said what you meant. You said these people were incompetent. I don't understand what the deal is here. Thank you, boss lady. Thank you for being a member for 29 months. I appreciate that so much. Thank you. And Nana Banana, thank you for being a member for 8 months. I appreciate that so much. All right, here we go. He said, you're entitled to your opinion, but I ain't want to hear it no more. All right, here we go.
All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed.
Hey, for everybody just joining it, welcome in. I see there's a Jade Raid. Welcome, welcome, welcome. This is the hearing that happened today. This is the latest news from Sarah Boone. This is what has happened so far. Sarah filed 5 motions. Okay. She wanted money allocated for a private investigator. That's granted, and they're going to continue with Prison Break investigations. She wanted money allocated for an expert witness. That was dismissed with prejudice, and she's allowed to refile because basically it was too vague. You can't just say, I want a expert witness. What you have to do is you have to explain what type of expert witness you want and why you need that specific type of expert witness. Then the JAC will say, well, we'll either grant it or we'll deny it. And then if they grant it moving forward, then you find that expert witness. So it's a bit of a process. The third thing that she wanted was she wanted funds to be allocated to depose witnesses. That was dismissed with prejudice, although she'll be allowed to refile. Again, it was too vague because this is going to be a little bit difficult, and I'm really waiting for either Mentor lawyer or the lawyer to catch up, to get with the watch this and analyze it, because I was thinking about this. So Sarah is pro se and she wants to take depositions. Well, my question would be, usually when there is a crime like this, when there's a violent crime, but particularly a murder, the defendant is ordered not to contact any of the victim's family. And some of the victim's family gave statements to police, which means that Sarah, under the Constitution, would have the right to question them and depose them. And I'm curious how that's all going to work out. See, there's a lot of nuances that make her being pro se difficult. So I'm curious how this is all going to play out, but that's what's going on now. And she asked for standby counsel and the judge said, no, not today.
With any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself,
they're going to address the logistics of the depositions here shortly. He does such a really good job of explaining everything that I didn't want you guys to miss out on any of it, because he does this. I like this judge. I'm a fan.
And some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
MK Lynn, thank you so much for gifting. For gifting memberships. You guys, if you got a membership from MK, please thank him. That was super generous. Thanks. I appreciate that, MK
That's
Lynn.
acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days.
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense.
Yeah.
And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of everything.
Oh my gosh, I don't understand. Mr. Cameraman, slow down. Okay, so LWLW said Darrell Brooks cross-examined his victim girlfriend, mother of his child, pro se. No interaction with victim, must be pretty normal. That's at trial. That's different. What Sarah's wanting to do is a deposition. Those take place before trial. And so, yeah, at trial, it is in the United States, we have the constitutional right to face our accuser and to question our accusers, okay? But usually we do it through an attorney. We don't actually do it ourselves. So it's one of the reasons why I think Ted Bundy wanted to represent himself, because I do think that he wanted to be able to question the survivors in Sigma Chi from the sorority. I let me not say that specific sorority. I think that's the right one, but sometimes I forget. But the sorority. He wanted to get he wanted to have an opportunity to question them for nothing other than, really, in my opinion, to terrorize them further, quite frankly. And it's happened in other cases as well, but Bundy's is the most notable. So yeah, I just think that it's interesting that she's trying to depose, and I'm wondering if the judge will put a limit on who she's allowed to depose. That's really what I'm curious about. And I don't understand I do understand, but also don't understand what the state is saying here. Let me keep listening and maybe I can make sense of it.
The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court, so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for.
So Carolina says, Cashman deposed Sarah Boone's witnesses. At least that's what Mentor lawyers said. Well, she may have done that, but just because Cashman decided to use those witnesses and therefore she deposed those witnesses doesn't necessarily mean that Sarah will also elect to use those witnesses and depose those witnesses, or even if she were to use them, even if they were the same, right? Which the deposition would be for the state. But my point is that Sarah might have different questions for those witnesses than Cashman. So even if let's say Sarah didn't, this didn't happen at all, and the judge gave her a new attorney, Cashman would have turned over that stuff to the new attorney, and that new attorney might have looked over it and said, okay, well, yeah, good night, MK, sleep tight. Well, yeah, some of these, I like some of these questions, but I would have asked, they forgot to, they asked question A, B, and C, and they skipped D, E, and F, and I want to ask D, E, and F. So she has to be given an opportunity to depose her own witnesses. It's, one thing that I think the only thing the judge is really like taking into consideration from her other attorneys' work, including Ms. Cashman, is the fact that Ms. Cashman did spend 20 hours with her and did go over some of the things that were in the discovery. So it isn't as if Sarah is completely ignorant of what's located in her discovery, what the discovery contains. I really think that's his point. There's going to be another point in here, and I don't want to skip too much because I can't remember where it is, but Sarah makes an interesting request And so I want to hear that. But anyway, I wasn't even reading the screen. And here we go. D and F for later. Skip an E. Here we go.
Later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
Go ahead, sir.
so I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay.
I'd really
And
like.
that would be September 1 to have the evidence viewing, for lack of a better word.
I would really, really like, I'm going to just mute this, but have it in the background and watch it because this is kind of back and forth and not really all that necessary. But anyway, I'm really curious when it does get to the point about the evidence. I'm super curious what evidence she's going to object to and what her grounds for objection will be. I'm curious about that. I think he's wearing a coat and 5, 6, 7, 8. Good to see you, by the way. It's been a while because even though Debbie was on the coast, Orange County is not all that far inland, and they got a bunch of the outer bands, and I can see from the window there that it's pretty rainy. Like we're still getting rain, and she made landfall hours ago. All right, here we go. Sarah's got stuff to say.
Two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a
I think it's a raincoat, you guys. I mean, I know it looks, I mean, I'm sure that he's wearing it. Maybe he is a little cold because even though it's hot here, when you are like running from the parking lot, into a building or whatever, and it was raining pretty hard and pretty consistently. I don't know, maybe he got chilled coming into the AC. I don't know. It's a little shocking to see because it's so extra, especially for Florida, but I think that's all that it is. Okay, hold on, here we go.
matter of any type of confidentiality. It is all done in the courtroom with everyone.
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
Understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections, such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions, and then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator, or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay, I get it now. First, I didn't understand what he was saying. This is the second time I've watched this part. Okay. So let's rewind it back just a little bit. I don't think he's talking about her actually taking a plea deal. Hold on. I think what he's saying is the way that they would handle it is the same way they would handle somebody who wasn't to the part of excuse me, hold on a minute. Sorry. Something got caught. If she were, okay, so this is what I think that he is saying. This is what I take it to mean. I don't think he's talking about her actually taking a plea deal. I think what they're talking about is handling it in the way that they would if they were going into plea deal negotiations, excuse me. She would have been smart to take a plea 4 years ago. What he's saying is they will go out there and they're going to record all of it and show Sarah the evidence that they have against her. And that's doing it under the confidentiality, the same way that they do it when they go out to visit people in jail when there is about to be a plea negotiation. I think that's what he's talking about, but I mean, I'm not an attorney. That's what it sounds like to me. I mean, I don't know, it's possible that, let's just finish listening and we'll talk about it in a minute because I'm going to play a little bit of Mentor Lawyer. So here we go.
I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator, or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay.
Yeah, see, they're not talking about taking a plea deal, because otherwise, if they were, then why would they get the private investigator involved? No, they're handling it in the way that they would handle plea deal negotiations, but it's not a plea deal negotiation. Okay. So LW says, why isn't Sarah sitting at a desk, and why no microphone like prosecutors, and why not street clothes? Okay. Those are good questions. I think that the reason they have Sarah sitting where they have Sarah sitting is because that's usually how they handle prisoners. They're going to have to change it for her. If Sarah wants to be allowed to wear street clothes to court, all she has to do is petition the court. It's all she has to do. That's all she has to do. And I think that I think when it comes down to the real pretrial stuff where she'll actually be arguing her motions, I think they will adjust the courtroom for her. But right now, this is sort of I'm just going to go ahead and give you my ruling on the motions that you filed so far. We're going to hand over evidence, those being the USB devices. And then we're going to work out some other logistics for how the rest of this is going to go. And so, yeah, I don't think that she's going to, I can't imagine if she were going to take a plea deal, she would have taken a plea deal already. Corky, she has a brother. Corky asked does Sarah have family other than the ex and her son? She has a brother. Okay, so I'm going to talk about what Mentor lawyer his visit with Sarah. Here we go.
Ms. Boone, what are your
Just
thoughts
want to
on
finish
that?
this up first.
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That is correct.
I'm clear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court with everything finalized and ready to go to answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, et cetera, would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it, but it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either.
Yeah, tell him. He's right. I mean, the evidence is highly, highly monitored, so there's no privacy. And I think Sarah's main objection is the media. She does not want the media to be able to see. I feel like it's more the reaction that she doesn't want the media to see that, because I mean, there are obviously stuff that the public and the media has not seen, right? There's the most sensitive information. mainly I would imagine it would be George and George's autopsy and all those pictures and all that stuff. So there are things that the public hasn't seen and we won't see because they won't. I mean, they're going to publish it to the jury. And when the trial is streamed, if you're watching not in person, they'll be published, but they'll be published to where only the jury and the lawyers can see. They won't be published to the public. They'll make the camera focus on that, probably that seal or something like that. How they always do that. So yeah, I mean, I just, I think that's her objection. I think that's her issue. And I do understand how people feel about this, because at the end of the day, Sarah's the one that put herself in this situation with the attorney. And I get it. She did. I agree. And that the longer this drags out, the more shenanigans get pulled, the more difficult this becomes. All it does is it delays justice for George, which is wrong. He and his family deserve justice, period. At the same time, if we just start throwing out rights and where then we, as a society, in my opinion, we become no better than the criminals that we are prosecuting, right? Somebody has to maintain some level of decorum. And even though at this point, most of us feel that Sarah is 100% guilty of the charges that she has been charged with, she still has the presumption of innocence in the court. And so that is what this judge is tasked with doing, is he has to be, nobody's rights are more important than anybody else's. He has to remain neutral. He has to maintain neutrality and equality. And that's what, he has to do. And so the rules do matter. And I will say this, part of the reason that this judge is being so extra, in my opinion, tempered and careful, is because these are extraordinary circumstances. And I live in Florida. So this would, I'm a Florida taxpayer. I would hate to see us pay, and the taxpayers are paying for this trial, both sides of it, all the way through. I would hate to see all that expense get laid out for there to be a misstep that gets the whole thing overturned on appeal, and we have to start all over again. That would be even more expensive. So, it is what it is. While I can appreciate, because I'm frustrated too, Sarah has manipulated and thrown a monkey wrench at every turn in the wheels of justice. And it's irritating and frustrating to me as well. But I also can understand and appreciate why the judge is being so careful and why he's doing the things that he's doing. So there we go.
So that wouldn't really be any different than if she's doing it in the witness stand or wherever you deem suitable in court.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lang to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here, just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it can't be transported anywhere other than here?
See, Sarah, this is why people feel the way they do about you. He just explained it. But before I forget, I want to say thank you to Paula very much for your kind words about enjoying the channel and the West Memphis coverage that I've done. I really appreciate that. I don't think it's going to get that far. Like, I don't think that anybody is going to, she's not going to go free. But what I will say is, when there are egregious errors in the trial process, it won't be people like, it's not the regular people, it will be the appellate judges. And so I think that's why he is being careful. Is, for one thing, who wants to have everything that they've ruled? Like, it'd be like me making all the decisions for my channel, right? Which I have done up until this point. And then 6 months from now, some stranger comes in and looks at my channel and does a complete overhaul without talking to me or knowing anything about me, just decides things need to be changed. That's about how it is for judges. They don't want their rulings overturned. And so I think that's why he's being careful, to make sure that his rulings don't get overturned, that he is fair and, at every opportunity, I mean, it would have to be something super egregious, and, it is what it is. I understand, but I stick up for Sarah's rights, which people get mad at me for, but I would do it for anybody. Everybody is entitled to their day in court. And even though I can dislike the crime, dislike the person, I can recognize that that's the way this country is. That's our rules, and we got to stick to it. But then he explains exactly why things are the way they are. And here she comes. I don't understand why it can't be transported anywhere other than. Let's rewind it a little bit and hear this ridiculousness. Sarah Boone. Here we go.
Just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it can't be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That
He
was
just
already
told
identified by the
you.
state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
She drives me nuts, Corky.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's
No.
a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent
He can.
media access.
There's
So
precedence.
without doing a little bit more further dive or research in that, I don't know if I can make that call at this time.
He can do it.
Yes, I have not heard of a case where the evidentiary hearing has been televised.
It's not an evidentiary hearing.
If you could please look into that, because I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize.
Lord.
We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical
Hey, Earth,
examination
good to see
here in
you.
court.
Hey,
At that
K-Brace.
time, if the USB drive or the, after our viewing here in court, state is it your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
Hey, Tucker
We are
Newsma.
happy to defer to the defendant's wishes on that.
Oh,
I
Lord.
want to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use.
I'm going to work that word into my vocabulary, duplicative. I like it. I'm actually kind of confused here because it does sort of make you wonder what this conversation is about. But then at the same time, like it's sort of like he's talking about 2 separate things, but at the same time. It's like he's saying, well, she wants to have, she spoke to somebody and now she wants to meet with us, but they're also simultaneously discussing how they're going to handle Sarah viewing some of this evidence because they can't take her down to, the sheriff's office or whatever. And it's, yes, Ro, okay. So she doesn't have to stay pro se. What she has forfeited her right to is a public defender. If she wanted to hire a private attorney, she is free to do that. If a private attorney wanted to work pro bono, she's allowed to do that. She just cannot utilize the public defender. So I'm super confused by this, and I can't wait for the lawyer, or mentor lawyer to maybe, to break this down, this part specifically, because it's a little bit confusing. I thought that I understood, but then it sounds like he's saying he's talking about 2 different things, but he's talking about them at once as if they're one thing. I'm very confused.
I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion we had about plea offers.
Okay, there we
One of the
go.
other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a
Uh,
list of the digital evidence that we seek to introduce. And that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of the discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane, who would
Okay, I understand now what's happening. I want to show you guys this. I saw this over the weekend and I couldn't figure out what it was. And now hearing this hearing, it makes sense. All right, let me add it to the stream. Can y'all see this right here on 731 correspondence? And you see this is confidential. Let me check. Can y'all see that? Let me see if I can make it bigger. Right here. That's what that is. That's why we can't see. I couldn't figure out why there would be correspondence that would not be public, why it would be confidential. And that must be what it is. This must be her, this right here that you can't get is marked confidential. This must be her having reached out to the state. That makes sense. Okay. All right, back to this. Oh, I have to share it first. Now I understand. So there is something that they are discussing with respect to plea deal. Why Sarah has waited 7 years, I don't know. But I think that I honestly think she's just going to reach out and hear what they have to say. I cannot imagine her taking a plea deal. I just can't. Disabled girl says, what exactly does her investigator do? So her investigator would go and he also sees the evidence and does the legwork, goes and speaks to witnesses, stuff like that, investigates. Exactly. Tracks down evidence, tracks down witnesses, investigates, looks at the case file, all those things. So yeah, I guess she did reach out and she does want to have some kind of meeting, but I cannot imagine that she's going to take a plea deal. There's no way, because I could have sworn there was a plea deal offered before, but who knows? All right, here we go.
then have to provide it to a member of the staff at the jail, the names of which I have, from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know.
Now, I find this part very, very interesting. She says, my phone calls have been released from the jail. You aren't, I mean, your phone calls are recorded, Sarah. And if they have been released, they're not, if they've been released to the public, I feel like by this point, we would have heard something. If they've been released, and I'm not saying that it's impossible that they haven't been released to the public. I just feel like somebody would have shared them. Hey, recliner detective, good to see you. It's been a minute. I feel like somebody would have shared them at this point. So I'm wondering if they have been shared, if it's the state who's looked at them or listened to them to see who she's taught, if she's made any admissions or whatever, because all that stuff can be used against you. All right, here we go.
I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously had worked on the laptop with USB drives that he has furnished himself, bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
D. Giovanni.
Okay.
There's multiple sergeants involved, and I did the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring it with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives in the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who?
No, you're understanding exactly what he's saying, Sarah, but you're objecting to it. Okay, here's the argument. She is saying that she does not want those USB drives in the custody of anybody at the jail. She doesn't trust the jail. She says they've leaked her phone calls, this, that, and the third. This is very sensitive information and it's going to go to the media, blah, blah, blah. That's her argument. And she doesn't understand why, because in the past, this is her acknowledgement of attorneys doing what they said they did, which is to sit down with her and speak. And also, say how that works, Sarah. Anywho, they were allowed to bring their laptops in, and their laptops, they, had their own drives, and they would go over evidence with her. So again, Sarah, you just admitted that you have seen some of your discovery. Stop playing with these people out here, Sarah. I'm trying to tell you. And she doesn't understand why that can't be a thing. Because, Sarah, that would require somebody coming to visit you every single day and chilling with you to go over all of this stuff. What the judge is saying is, I'm going to let you use your own laptop that's provided to you at the jail so that you can go through your discovery at your leisure and not have to wait for like your private investigator to do it. That's what he's trying to do, but she's not happy with that. So here we go.
And I read it to you at the last hearing.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get involved with your harassment or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and was provided by U.S. Mail. It was sent out last week.
I didn't get to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive.
Okay.
Gotcha.
All right.
So anything that you were speaking of in the meantime, I do not know, and it was served by process,
It was served by U.S. Mail.
by U.S. Mail? Yes. I actually have 3 motions, if I may, submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with a laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail, so by me trying to get a hold of the captain nonetheless, is going to be a feat in itself. So I want you to know that anything that I am in the process of trying to reach out to the captain, I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing. So here's what we will do.
Sarah, what is it that you think is going to happen with your evidence? I mean, I'm serious. What do you guys think she thinks is going to happen? Does she not realize that all of those things can be traced? That anytime you use a removable storage USB drive, you plug it in, anytime you can see when it's been accessed. So anytime it would be accessed would be outside of the time period that Sarah is allowed to have it. So if there would be a record of it. And this is why you should have listened to your 8 lawyers, Sarah. Jeez.
We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
Again, caveat in that order being, unless it hasn't already been done.
What?
in case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3.
Oh.
But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place.
Understood.
Okay, thank you very much. Ma'am, we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to these state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I will be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get next.
And what is your affiliation with the state?
I'm the homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
That you can do that. And like I said, Mr. J, if you could follow that notice, just to identify when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to, so I know Thomas is looking on it for the laptop. I do not have my discovery as of yet, and I do not
Oh
have
my
a laptop.
God.
I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out
No,
when and
Alice,
where I'll be
quit.
able
Get down.
to review anything, so there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptops in quotes, closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not.
All right, class, please raise your hand and answer the question. When will Sarah Boone get her damn discovery? I mean, he's explained this to you 8 times, Sarah. I mean, what do you need? Crayons now? You need him to draw it for you? We're not even going to be able to get to Mentor Lawyer because we've already been on here for an hour and 43 minutes. And she's just out here doing too much. I might have to do Mentor tomorrow. Here we go.
Not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I had already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by bringing that topic up, I have that to also be looked over.
Okay.
Please. 917, if that has to be changed, then I okay to.
Ease the pain of everyone here. Sarah, you could ease the pain of everyone here by actually listening to the answer to your question rather than listening to respond and then asking the same question again, but you're using a couple words in a different order. You're really just you're not even using new words. You just ordered the words differently. Oh my God. Here we go.
Do that?
I'm trying to set deadlines now, ma'am. And that will give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I'm very weary to make these kind of deadline.
Well, we're setting them today,
I understand. So the 3rd is a what day, Thursday?
Tuesday. So the 17th would be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence,
You have 62 days to prepare for trial, not including today, and you're going to get your discovery today.
wow. So in over 4 years, it comes down to me representing myself in 62 days.
I'm not going to answer that question.
Am I supposed to?
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most rather, to lodging objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay. And if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yea or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet, your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable, I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also, if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else if they just delegated the dates and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question.
Okay, again, Sarah, the JAC has kindly said that they are going to provide you what's known as a pro se packet. It will give you the models, the templates, if you will, to base your objections around, okay? And you can you can ask the judge 11 billion times, but he's asking for an answer. You either agree to the 17th or you don't. And then you got to tell him why. Maybe say something like, this 2 weeks doesn't seem like enough time. I've never done this before. Can we make it, instead of 14 days, can we make it 20 days? That's all you have to say, Sarah. That's all you have to say. Instead, you're arguing and being belligerent. Again, an attitude that has served you so well in the past. Keep it up, lady.
I'm not allowed to.
Okay. Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay, expedited. Sarah, literally every single letter that you have written thus far, except for, I don't know what this newest letter is, it contains, because it's not available to the public. However, you have always started your letters with some type of counting system for the time that it has taken since your last letter, since you spoke to an attorney. You're always doing the time. You're always calculating time. This is not expedited at all. This is slow.
Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now, I want to address the deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testified in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to, and that are limited to only 15 minutes that I have to share with 62 other inmates. That is a hurdle fee that I need you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Whom is it that I need to speak to in order for this?
We may be to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and also because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is it that you're asked? Which, the protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding
Sure.
USB.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. I sent it to Anita, that's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
I cannot imagine, you guys, that they would give her access to the internet. I really don't.
You all this evidence, ma'am. When in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. there's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I can't promise anything because I do not know how I will be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain, so I can see if I can have access to a regular phone, if I can have access to an internet. Right now, I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone, I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to the discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, make a state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to use at trial is provided to her. So, for example, the physical evidence, which we plan on getting her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her would be our suggestion.
Okay. Ma'am, are you amenable to that? 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists?
I don't feel comfortable with any of this. I
Oh,
don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these dates which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to many more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm stating my good cause is now, if not there are additional at that time.
you have to state it
Ma'am,
then
right now,
too.
the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you were to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Mr.
Okay, all right. I will set a deadline for the review of September 26th.
Is the review that you're speaking of, please, for my exhibits and witness list?
That is correct.
Oh my God, where were you, Sarah?
I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes, and if I may ask, please, what you're typing, is that for an order or for today's proceedings?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'll have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to your proper address due to that clerical error that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections.
Okay, I know that this is gonna sound weird because of how much I've been like looking forward to this trial, but can I just point out that if you guys are as annoyed as I am, that this is what we're in for at trial. So now I have reservations.
Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts, thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that you
Yeah,
addressed this
Please
morning?
be specific or she'll just start asking all kinds of stuff.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here. All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in. You can stay to the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk's going to go ahead and swear you in. All
Swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
right, sir, good morning. Could you state your name for the record?
Sergeant Casey?
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown port holding, ERC courts, medical security, and the juvenile assessment center.
Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay, Mr. Lane, can you come on up here, please, sir?
Yeah, let's get this show on the road. No more questions, Boone.
Sir, good morning. Can you raise your right hand? Madam Clerk's going to swear you in. All
Please swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
right, sir, good morning. Could you state your name for the record for me?
Willie Lane,
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you with digitizing 2 banker's boxes of information. And you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those, this drive here is a copy of all digital discovery that I have in my possession from Boone for the court's needs if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 banker's boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you had previously by virtue of being the investigator.
Yes, sir.
Okay, all right, the record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you please take custody of those 2 thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop. It'd be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you can proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain DiGiovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved.
Oh my
Please hand me
God.
the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 banker's boxes. Did you bring those back with you, sir? Okay, could you bring those back up? I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes? Okay, I'm gonna have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor. Thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
Oh God.
My intent to try to get out there at the end of the week or beginning of next week.
Thank you.
Thank you, sir. I appreciate you.
One housekeeping thing.
Yes, sir.
I don't know if Mr. Blake, since he's here, would like you to sign my invoice or have Ms. Boone do it since she's pro se.
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it.
Okay, that's fine.
Okay.
Is it okay if I?
Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable, yeah, if Mr. Lane, and you know, in light of this, maybe it might be more appropriate for the court to go up to 10,000 for the investigator, because it sounds like you've already done a lot of work. So it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
One thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses and some out of county. If not, I can get that in some type of form of writing and get it to you or to the JAC. That's acceptable.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, say, $1,000 for travel expenses as well.
Who's who, Roro? I'll tell you. This is the private investigator. This is the representative from JAC who is in charge of money. If you are an indigent defendant, this is who is not this specific person, just in this case, but the JAC is who is responsible for paying your private investigator, your expert witness, stuff like that.
Fine, so we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need a word for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will have the ordinance in this.
All right, very good. Just send it to Ms. Barrios, who I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thanks, sir. Mr. Lake, thank you so much, sir.
Yes,
All right.
Judge Bennett,
Yes, ma'am.
what is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants.
Look at me.
All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing, I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
Oh,
I can't speak to for or anything, but based
My
on what we
God.
discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness.
He will be there.
tonight also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought with you this morning.
oh, here we
All right, if
go.
you could hand those to the deputy. Also, to the extent that the deputy has not already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you, it was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, is she being who, the captain?
Oh, no, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document proposing the dates for today's hearing. And I guess it's some type of notice. That's what please that she was going to print out to give to me, so I have that.
Okay. Mary.
I did not receive that, nor did I receive this protocol notice.
As to everything that was being discussed, can you print a copy? It should be in the file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
All right, let's skip through this.
Motion, as that's our action. Well, ma'am, with regard to one of your motions, the motion for defendant's immediate address correction, as identified earlier, there was a clerical error using the general PO box as opposed to legal mail. That's been remedied. So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail.
Well, there you go, Sarah. You got one down. Good job.
It is the motions for hand.
Jesus, I'm leaving
Mr.
it
Jake, you
alone.
want to approach, sir, to review the hand-delivered motions. It is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. Second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, (A, B, parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case. Just review those, Counselor. Just let me know when you're ready to address them.
Your Honor, in regards to the first motion, we need to notice the sheriff's office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay, all right, I appreciate that, sir. Ma'am, with regard to your request for discovery, of the hard copy discovery, you've advised me multiple times seeking to use a laptop. I've written correspondence from you asking for a laptop.
Uh-oh.
That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, to my understanding, in communications with the captain to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I never,
You have written letters, ma'am, specifically asking for a laptop
do you know what the date of that is?
without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom of movement, well, I'll notice the sheriff. We'll try to set that up for this week so that can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by sergeants,
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach. By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding, that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited, restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then take out the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion.
Oh my God. This is not difficult, Sarah. It's real simple. Real simple. Okay? There is nowhere to keep your discovery. It doesn't matter if you want it or you don't want it. There isn't a place for them to keep it. And let me ask you this furthermore, okay? You want your hard copies at the jail with you. You've already acknowledged that you don't have room in the space that you occupy day to day. However, you reminded the court that they have a property locker situation going on. But 27 minutes ago, you argued that you were uncomfortable with the jail having access to your discovery. You do realize that what's on those drives is the same thing that's in those boxes, right?
Process was created, and I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag, a property bag, that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together.
Hey, Allie B,
And
good
as I
to
told you,
see
we
you.
worked diligently to
Welcome.
move forward, to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those two bankers' boxes. Ms. Barrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's two bankers' boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs. I was never asked anything, just like my letters to you prior to you forfeiting my right to counsel, I was never asked anything in order for you to have a better understanding.
Jesus fuck. We've gone through this like 87 times, ma'am. You said that your attorneys were incompetent. They were not only were they not doing their job, they were incapable of performing their job duties. Why would you want somebody who is incapable of performing the functions of their job? Stop it. You're just arguing to argue. Nobody's taking anything from you. And anyway, why would you, the paper would, at least when somebody accesses a drive, you can see when it's been accessed. You could have all manner of people thumbing through your boxes over there and you'd never know.
I'm not going to revisit that.
Please,
I am
thank
not-
you, Judge.
You never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week.
Okay.
So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she said to return. She's set to return on the 12th.
So if the document, what would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
I mean, I would entertain an or tennis motion to have it released from evidence. The concern as, and Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those two bankers' boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those two bankers' boxes because of A, storage, and B, because of the hazard. Now, if the jail is in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I'm 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided, and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
Actually, I'm just trying to find a solution. So
Same.
if she moves or tennis to release those two exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when the captain's back.
I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lade's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
Okay, so if she wants to ori tennis, which means oral motion, move to release those two exhibits, the state has no objection. And it sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so she's advised. So I don't want to ask her, but perhaps the court can.
Sure. Ma'am, the state has recommended a position for, in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask that of the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the captain and whomever, you can release them to me?
Granted.
No objection to her motion.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those banks.
See the games that she plays? She said she doesn't understand yet actually answered exactly what it is that she needed to do. So you did understand. Stop playing with these people, Sarah.
Boxes. I will have Ms. Barrios coordinate a hearing
Lord.
for the 13th at 8:45. We cannot do it the 13th because it's pre-trial. You're correct. We will have a hearing on August 14th, if necessary, on
Poor
Wednesday,
Mr. Lane.
August 14th at 1:30, if we need to address the jail's position in taking hard copies if Mr. Lane's unable to have it delivered. Mr. Lane, you advised earlier when Ms. Boone had inquired of you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that that information was provided to the jail on what date and to whom. Okay. All right. Thank you.
Your Honor?
Yes, ma'am.
What would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop, we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it. If we need it, if we don't need it, we will not have a hearing.
That poor guy. He already had unloaded the boxes, got all his paperwork squared away, folded up his little rolly thingy, and now he has to do it all over again. Sarah?
Thank you. And then so there would not be needing to be made an updated evidence control sheet right now. It has been passed to Mr. Lane.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, I was at 8, please.
Oh, that is the 9th, ma'am.
Oh, yes,
We're available.
Paula.
Okay, Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
God, I hope not.
Not from the state.
Anything else we need to address, Ms. Boone?
Please bear with me, just please, 1 moment.
Uh-huh.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to
Oh,
research that matter a
God.
little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd.
Okay. So Brandy wants to know, what is the reasonable freedom hearing? She's asking that she not have to be in cuffs the entire time she's in the courtroom. That's all. They're going to grant it.
That's deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided, the names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, represent yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom and during the evidence, should the physical evidence that I might be able to utilize that?
What? They're not going to hand you your phone. They'll hand you the download of your phone.
So my understanding is there was an imaging done on your phone with software called Cellrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person to hire. I know that defense attorneys in this area hire somebody named Richard Connor, Connor, and then that will be between you and the JAC and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him, with us being present and one being present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, the legal expert that can give me a near download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list here the mayor if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all of that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
If it's not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. But there is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence. Because like you said, there's so much of it would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience with other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds of thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We were going to make sure that that's taken care of.
And now,
What
just
would
as
that be?
clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Mrs. Cashman identified, she had everything. It's already been digitized for you. And to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return from the jail.
Yes, thank you. None of it was.
We know you
brought
didn't
up
have it
or
before.
With Ms. Cashman or any prior, so.
Great.
It would be a milestone, a big milestone for me to be able to finally do that. So now, if I don't have what I need or I'm looking for, how do I go about? I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy near download of my phone.
You demand a discovery.
Two for physical, but the other physical.
So again, that's going to be something that requires an expert. And then if you get a defense expert, and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, you're going to make sure that that is provided.
Okay, so that is not able to be included in the other physical evidence that you all supply.
No, what I'm saying is,
Oh my
there's 2 different
God.
ways that I see phone extractions. One is the PDF, which is what I think you're referring to, is the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program. And all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before, just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes, I am grateful for your information. Just to clarify, please, during the physical evidence and viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No.
Okay,
It needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of the phone.
thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
Please, Lord, no, don't let her ask anything else. They're going to have to, I'd like to motion the court that Sarah only be allowed to ask 5 questions per hearing.
Okay. Your Honor,
Yes, ma'am.
I believe I am okay right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access where I don't know if emailing or messaging or whatever, however it is that you and I can communicate. Rather than snail mail, I mean writing a letter. I don't know when I write a letter, how soon you receive it, because sometimes it's days or weeks that it's uploaded to the clerk's website. Do you have a general time frame of when you actually know something? Because like, you already had my address correction, but I don't believe updated.
It's been updated now.
Not on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or I'm able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and
Can
telephone
y'all
number
imagine?
in the order setting the deadlines that we addressed this morning.
They start letting her email people.
I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or portal or whatever it is that I might be attached to in order to receive notices to be called in here?
Notices have been sent, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State anything else?
No, Your Honor.
All right, we'll see you all Friday. Thank you very much.
Thank you.
Oh my
We'll return Ms.
God.
Boone to the custody of the Orange County Jail.
Take her away, boys. Take her away. Oh my gosh. Can you imagine if Sarah were given a direct line of communication with the judge? Also, I'm thinking about it and I don't remember her asking for a laptop, but that it doesn't mean she didn't do it. I just don't remember it. I mean, it wasn't just a bunch of nothing. They did get stuff resolved. It's just that Sarah is very difficult and she doesn't really like to cooperate. And when she asks a question, she doesn't listen to hear a response. She listens to respond. She's already thinking up her retort before the person speaking has even begun to answer her question. It's ridiculous. All right, you guys. Well, this is what I was going to talk about also tonight, but now it's late. I don't remember that, Nella. It doesn't, just because I don't remember it, obviously doesn't mean anything. I probably, needed an extra room for some movie reference or a song lyric. And so that little bit of memory got pushed out or overwritten. But the Mentour, Deep Dive True Crime Mentor lawyer went and saw Sarah, and he did see Sarah, and it was under the attorney-client privilege. However, he did say that they both sat together and agreed about what he could and couldn't tell his YouTube channel. So he was going to read that off, and I will maybe come live tomorrow night and we can talk about it. All right. Well, I want to thank you guys all for being here and hanging in. And if you've made it this far on Replay Crew, I appreciate you too. Welcome to the new members. Thank you guys for being here. I I am going to play the outro, and then I will bid you guys a fond farewell. Good night. Have a great rest of your Monday, what's left of it for you people that are not on the East Coast. It's already Monday here, or Tuesday here. But anyway, thank you guys all so much for being here, and I will see y'all tomorrow. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious content or effort was towards it.
No malicious. Pity time.
Minutes later.
We all do a little mad sometimes.
And you know this, man.